All rise, voulez-vous le verre? The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer les fonctions résiduelles des tribunaux pénaux est ouverte. Please be seated.
Good morning, everyone. Would the registrar please call the case?
Good morning, Your Honors. This is case number MICT-13-38, PT, the prosecutor versus Félicien Kabuga. Thank you, Your Honors.
Who appears for the prosecution?
Good morning, Your Honours. Same team as last week, so myself, Rupert Elderkin.
I'm sorry, I'm not hearing anything through any headphones. I've tried to.
I'm more than happy to talk. So again, good morning, Your Honours. For the prosecution, the same team as last week. Myself, Rupert Elderkin, case manager Thomas Logel, the prosecution's advisory consultant, Dr. Bennett Blum, Mr. Rashid, and Ms. Yakusheva.
Thank you, Mr. Elderkin. For the defence?
Good morning, Your Honours. The defence team is made up today of Ms. Nauri, Mr. Jacobs, and myself, Emmanuel Altit.
Last week, the parties and the trial chamber put questions to two independent expert forensic psychiatrists appointed by the chamber, Professor Henry Kennedy and Gillian Maisie, as well as the prosecution expert forensic psychiatrist Dr. Bezosa. The parties informed the trial chamber through informal communications on 19 and 20 May that they did not need to put questions to the third Chambers appointed independent expert in gerontology, Professor Matache Rasso. As a result, the trial chamber has decided that he need not appear in court for questioning. Today, the trial chamber will hear oral submissions from the parties on Mr. Kabuga's fitness to stand trial and to be transferred to and detained in Arusha. The defence will make their submissions first, followed by those of the prosecution. The defence has estimated it will require approximately 45 minutes and the prosecution estimated 30 minutes. The trial chamber also asked the defence to confer with the accused and to determine to what extent these hearings may be held in public. Now, Maître Altit, can I turn to you to ascertain how much of the hearing you consider can be conducted in public session?
Your Honour, after reflection and after discussing it with Félicien Kabuga, our conclusion is that the best would be probably to have part of the hearing, a small part of it, as a public session, and the remainder, particularly when we're talking about intimate details, in private session. And we sent a request in writing to this effect yesterday evening.
Mr. Elderkin, can you indicate your position on the question of the extent to which your submission may be in public?
Yes, Your Honour. I had a brief conversation before today's session with Maître Altit and told him that I expected the vast majority of my submission to be able to be in open session. We have identified a couple of places where I'd ask for private session, and I also invited Maître Altit, if at any point he thinks I've gone beyond the fine line of what should be in private session, to indicate. I know we don't have a sitting public gallery today, and I understand there's a delay for the broadcast, so I would welcome any indication if we need to step back and ask for something I've said in open session to be put into private. But we have reviewed it with the thinking as to what can be and what can't be in open session.
Thank you. The position of the bench is that we are content to trust your respective judgments on the extent to which you conduct this in public. And I only envisage the Chamber intervening in the event that we have a clear view that you have perhaps erred in your assessment. I don't anticipate that happening. I anticipate that we will be safely controlled by your own judgment in what's appropriate for private and public session. Now, Maître Altit, you have the floor to make your submissions first. You could perhaps indicate whether you wish to begin in open or private session.
Thank you, Your Honour. Your Honour, before we begin, if I may, if the Chamber allows, we have a request, the prosecutor and we, submitting a request, which is to spend a little bit more time, and I'll allow the prosecutor to explain how much more time is required. As far as I'm concerned, it would probably be an additional 15 to 20 minutes, would bring us to a total of around about 1 hour, all things taken together.
What the prosecutor has to say on this, Mr. Elderkin?
Your Honour, indeed, having got into the real detail of the submission, I realised that a little longer would be needed. So I would estimate that what I have to say looks like more 50 minutes than 30. And of course, I fully agree if Maître Altit has discovered he needs the additional time indicated, we don't object at all. I would simply ask that we be allowed to go a little longer than I had hoped for when we spoke last week.
Well, let's just get started and not waste any time discussing time. Maître Altit.
Thank you, Your Honour. And in answer to your question, we will be beginning in public session. Your Honours, for us, everything is clear, extremely clear, in fact. After the explanations given by the different experts giving their view on the physical and mental health of Félicien Kabuga, and in view of the elements in his medical file, it strikes us that Félicien Kabuga is unfit to stand trial, and that strikes us being the only reasonable option. His lack of fitness today is a medical fact. It is not a matter of opinion. First of all, the facts. As of 2016, and you will recall that defense submitted the MRI to the case file in 2020, but in 2016, an MRI on Félicien Kabuga showed already that he was suffering from a diffuse and bilateral leukoariosis. In other words, diffuse anomalies of the cerebral white matter. And it was said of this, and I quote, that this could testify to a degenerative process, end of quotation. When an MRI was carried out on the 6th of November 2020, the radiologist noted, and I quote, a diffuse parenchymal loss in both hemispheres with enlargement of the sulci, anomalies of white matter, particularly in the frontal zone. End of quotation. Following this MRI, the doctor at the UNDU indicated in his report of the 18th of November 2020, and I quote, a general diminution of the cerebral mass, parenchyma, can contribute to the diminution or impairment of the cognitive function, end of quotation. As for the MRI that was carried out on the 22nd of January 2022 at the request of Professor Mizi, it shows, according to the radiologist, and I quote, a severe parenchymal loss that is degenerative in both hemispheres with anomalies of the white matter indicating a profound microvascular impairment of the white matter, ischemia, partially hemorrhagic, with anomalies in each hemisphere, frontal and to the right, at the level of the semi-oval center. Grade 2 atrophy of the hippocamp, clinical frontal syndrome, end of quotation. The hippocamp is where the memory is located. The frontal lobe is for behavior. So what does this medical report signify? As of the 1st of October 2020, Dr. Shook indicated in a report that was filed on the 5th of October 2020 that Félicien Kabuga had a leukoariosis, and I quote, that was externally manifested by a degenerative dementia process. That was in 2020. Professor Mizi indicates in her report, and it's page 56 of the 28th of January 2022 report, and I quote, a recent cerebral MRI shows signs of structural modifications and impairment that are generalized and local, characteristic features of Alzheimer's disease, and would clearly indicate the presence of the latter, end of quotation. And, Your Honours, this is what Dr. Rezo would appear to be saying, having been apprised of the MRI, concluded on the 16th of February, and I quote, the diagnosis of dementia is based on clinical findings The radiological findings give information on the nature of the process. Cognitive disorders have progressive character, and in individuals with frailty and comorbidities, it is expected to deteriorate over time. End of quotation. So dementia, Alzheimer's, degenerative process. This is the evidence.
To clarify one point, in Dr. Chuk's report, the reference is to a degenerative dementia process. Like Professor Maisie, are you saying that she's not clear whether this is the result of the development of dementia or is simply a generalized degenerative process? Or do you say that she reaches a conclusion on what might be the cause of the deterioration in Mr. Kabuga's mental capacities?
Your Honor, here I am noting the facts, and I'm using the terms used by the different doctors, cardiologists. Alzheimer's, if I've understood correctly, is a form of dementia. So it is logical that some will talk about dementia, others Alzheimer's, in view of the evolution of dementia towards Alzheimer. The degenerative process, if we understand what all of these doctors and cardiologists say, is a fact. And if I may, I'll come back by clarifying a number of things in a few minutes' time. But the important thing here is clearly that the degenerative process leads to dementia, which can be characterized by Alzheimer's or not, according to the different doctors who have given their view. But there's something else that is evident, and I'll come back to that as well, and that is that it is a process. The current state of Mr. Kabuga is far worse than it was yesterday, and it'll be worse tomorrow than it is today. If I may, I will come back to these points because you're quite right to raise that. It's an essential point. On the 1st of June 2022, Professor Maisie explained to us, and this is the transcript, pages 5 and 6, and I'll quote, because it's particularly important. I quote, "I think the important thing to say is that there is a substantial loss of brain tissue. That's parenchymal damage, which the MRI refers to, and there's also focal damage. So there are specific areas of the brain that have been destroyed effectively, and that is what the scan shows. That is not it's not a normal MRI or an MRI that, if you like, is consistent with an elderly brain, normal aging." End of quotation. And she added, and this brings us to your question, Your Honor, I quote, "I think that actually the MRI shows very clear evidence of the sort of changes that are normally associated with Alzheimer's, the most common form of dementia. And that is the actual loss of brain tissue, the shrinking of the brain, which is not minimal or insignificant, but is described as substantial. And there are also the focal areas of damage which are to the brain, which are probably caused by a series of mini strokes, which then affect specific areas of the brain. And those areas of the brain are responsible for particular areas of functioning. For example, the hippocampus is responsible for memory, or affects memory. the frontal area of the brain may affect areas of behavioral control, emotional expression. The disinhibition that one sees is a feature of frontal lobe damage. And she says, yes, I think this is very significant damage to the brain, which is evidenced on the MRI. And in my view, I would describe that as a picture which is consistent with dementia, end of quotation. So, the medical noting and interpretation is that we see that this is first and foremost a question of neurological damage. It's damage to Mr. Kabuga's brain that affects his physical and mental capacity. And this is clearly what is shown by the medical experts' reports and these reports that have been filed in this case. Professor Mézy refers to hypertension and says that Félicien Kabuga has medical problems that render him more liable to episodes of transient ischemic attack. And she says, and this is the page 15 of the transcript on the 1st of June, he's had not just one attack, he's had several, as evidenced on the MRI scan. And she says it's probable that these TIAs would be repeated and recur. Experts have said to you, have said to us, that would have been a good idea, useful, to have the opinion of one or several neurologists. And as far as we're concerned, let me recall that we had actually asked, the defense had asked, before Félicien Kabuga arrived in The Hague, and then repeatedly, including on the 22nd of January 2021, that a neurologist be appointed as an expert. Nonetheless, the Chamber today has adequate medical elements in order to decide a lack of fitness for trial. There are all of the elements there, all of the elements, the MRIs, radiologist reports, opinions, explanations of the experts, and all of the symptoms of the disorders affecting Félicien Kabuga, all of this to allow you to take an enlightened decision. So, in answer to your question, Your Honour, as regards the processes involved, I think Professor Mézy was perfectly clear. She explained to us that, in fact, there were two parallel processes at play, and they are linked, and they are behind the neurodegenerative mechanism. This is page 50-51 of her questioning on the 1st of June 2022. This is what she says. Vascular cognitive impairment is a precursor to a dementing process. The areas of the brain that have been damaged lead to the loss of certain functions of the brain. We've got a clear documentation of vascular cognitive impairment. For instance, when he was in The Hague on the 22nd of July 2021 and 21st of January 2022, Mr. Kabuga suffered attacks. What has to be understood, she says, is that there's a continuum between vascular cognitive impairment and dementia. And I think this is an essential matter. So there are strokes that led to damage, and Félicien Kabuga has a brain which is showing the features of a brain of somebody affected by dementia or Alzheimer's. In fact, you've got the two processes. You've got the vascular cognitive impairment, leads to damage, and dementia. The vascular cognitive impairment or strokes can not, in some cases, perhaps not be visible, not be apparent. But in general, it's a crisis. It is treated, and the person either recovers or not their previous capabilities. It's, in other words, there's a decline stepwise. And then she explains that in parallel, there's a degenerative process underway, which does not function by steps, but can be reached when there is a crisis, for instance, a stroke, that can accelerate the degenerative process. But the degenerative process will continue whatever happens, whether or not there is a crisis. These are two intimately related processes. So once this has been noted, and once we've seen that the brain is severely impaired, and once we've understood the origin of this gradual destruction, we have to take a look at the causal link between the dual degenerative process that I've just spoken about and the problems of focusing and behavior that we see in Félicien Kabuga. The dual degenerative process is, or rather, the problems of focusing and behavior are the consequence of the degenerative process. Your Honor, I would ask that we go into private session, please.
We're in opposition, Your Honor. Thank you.
Thank you. Maître Altit, please continue.
Merci, Monsieur le Président.
Thank you, Your Honor. In other words, and I would like to refer you to page 75 of examination of Professor Mezzi of the 1st of June 2022. Somebody with such damage to his brain cannot have a normal cognitive functioning. It has to be said clearly. Somebody with such a brain cannot have normal cognitive capacities. Now we can better understand the origin and the nature of the impairment for which Mr. Kabuga is unfit for trial. I would like to talk about the position of the prosecutor for a short while. Position on the MRI. Faced with this objective finding, I would like to start again. I would like to talk about the position of the prosecutor regarding the MRI. Faced with this objective finding, how does the prosecutor tries to get out of this situation? During the examinations of Professor Kennedy and Mezzi, he tried to challenge the use of examining an MRI to assess the situation and make a diagnostic. But this approach contradicts any scientific and medical approach applied in this field. Just as Professor Mezzi was explaining it very well on pages 75 and 76 of her examination of the 1st of June 2022. She was telling us that faced with the clinical finding, such as the one presented by Félicien Kabuga, the normal procedure is to do an MRI to validate and specify the diagnostic. She was surprised that no MRI had been done since 2020, as Mr. Kabuga had a series of ischemic attacks and possible strokes. He had also had episodes of delirium and heart problems. And the cognitive deterioration had been evidenced by the medical team of the detention center. The prosecution is trying to bring us on this challenging of the MRI. The prosecution is trying desperately to ignore the irrefutable proof, irrefutable evidence, objective and scientific, which tells us what the state of Félicien Kabuga is. It is also an attempt by the prosecution to negate the validity of the normal methodology, which is followed in the whole world, and which makes it possible to diagnose dementias, and which is always supported by MRIs.
Monsieur le Président.
Your Honor, with your authorization, could we go into closed session, please?
Very well.
We're back in the session, Your Honor. Thank you.
Please continue, Maître Altit.
Merci, Monsieur le Président.
Mr. Altit, thank you, Your Honor. After having looked at the physical and mental capacities of Félicien Kabuga to find that he is obviously unfit We now need to address one point that was addressed during the discussions, and it is the question of malingering. Could he be malingering? This is what Professor Kennedy seems to say, because he asserts that there would be no scientific explanation for some absences of Félicien Kabuga. And because he replies to you, Your Honor, when you question him on page 44 of his examination, he replies, and I say, and I quote, that Félicien Kabuga could seem to wish to appear more confused than he actually is, end of quote. But the position of Professor Kennedy is contradicted by the conclusions of other experts, and it is founded on, it is based on nothing at all. And Professor Mezi explains this very well. In her examination of 1st of June 2022, page 24, Professor Mezi says that it wouldn't be reasonable to conclude that a person suffering from the pathologies from which Mr. Kabuga is suffering could be able to malinger, to successfully malinger on such a long period of time, and faced with a number of persons, such an important number of people, and in such different contexts. She also comes back on this very point on pages 25 to 27, when she says that what she observes from the behavior of Félicien Kabuga is not objectively compatible with malingering. She also adds that it doesn't seem that there would be any benefit to malinger some symptoms, which should actually be the aim of such a malingering process. Your Honor, judges, what should we conclude from these findings? And I would like to insist on the word findings. That the neurological impairments are so important, the degenerative process so advanced, the impairments of Félicien Kabuga are so numerous and deep, that the only conclusion to draw is that he is physically and mentally unable to understand his environment, to comprehend the events he's facing. And that consequently, he is not fit for trial. In these conditions, one can better understand, as Professor Meze explains, on 1st of June 2022, page 65, one can better understand that he is unable to learn new information. She says even more. She says that he has lost the capacity to learn, and that he loses what he actually knew. It is interesting to note, Your Honor and judges, that beyond memory, it's the question of the relation with reality that is presented. In her report, Professor Meze shows that Félicien Kabuga is unable to distinguish what is reality and what is not reality. He does not remember living in France. He does not remember being arrested. He doesn't even know that he is detained in The Hague. In order to judge of the cognitive impairments of which Félicien Kabuga suffers, one can note that when the doctor of the UNDU, who follows Félicien Kabuga since he arrived, and he was present during the discussion between Professor Mezi and Félicien Kabuga, Félicien Kabuga told the expert that he has never seen or met Dr. Falker, who was there, and that he did not know who Dr. Falker was. End of quote. The lack of fitness, which when one is interested in the facts and only in the fact, the lack of fitness needs to be it needs to be concluded to the lack of fitness. Professor Mezi and Dr. Chuk consider that Félicien Kabuga is unfit to follow any kind of proceedings and to interact with the defense, whatever the arrangements the court could put in place. Now, a few words about participation. And this is fundamental. The lack of fitness is even more obvious as the participation of an accused in his trial needs to be real. The accused needs to understand what happens during a hearing. He needs to understand not only the substance of the testimonies, but also the reason why such witness takes such position. He needs to be able to compare all the evidence, to understand the weight of each of them, and to understand the weight of the evidence as a whole. And he needs to be able to tell his defense what elements it should use, considering the case of the prosecution. In other words, he needs to be able to discuss the case, which means that he needs to be able to understand it. And Mr. Kabuga obviously is unable to understand it. Your Honor, judges, I said what I wanted to say. Whatever the manner we try to look at the question of the lack of fitness, whatever the angle with which we examine the lack of fitness, one needs to find that Félicien Kabuga is entirely unable, physically and mentally, and consequently, he's unable to take part in his trial. Whatever the standard for participation, even the lowest that one could imagine. Let's say things clearly. Félicien Kabuga doesn't understand anything. No doubt is possible here. He needs to be declared unfit for trial. So you will ask me then, what about Professor Kennedy?
The position of Professor Kennedy appears strange. While the impairment of the brain is significant, and clearly we're faced with a degenerative process, a very advanced neurodegenerative process, how can Professor Kennedy claim that everything is fine and that the cerebral impairment of Félicien Kabuga would have no physical or mental consequences? Professor Mézé said she didn't understand this. On the 1st of June, on page 18, she said that the conclusions of Professor Kennedy are not based on anything, and they are not based on the medical imagery and the clinical findings of Professor Kennedy himself. She says, there is proof of problems of short-term memory, problems dealing as regards the ability to retain information, to process information, executive functioning, and the ability to organize information. And she adds, and this is page 20, and I quote, "I do not understand Professor Kennedy's conclusion that there is no impairment, and I certainly do not agree that the MRI scan is the sort of brain that we would see in most 86-year-olds. It is an entirely abnormal brain, and that is why the radiologist refers to mild, substantial loss of parenchyma, which is a characteristic feature found in Alzheimer's and other types of dementia." End of quotation. What is more, Your Honours, you will have seen the tendency of Professor Kennedy to play down the symptoms or to ignore them, and to play them down even further. He has a tendency to provide speculative explanations, which is clearly not a very scientific approach. You will have noted as well that his explanations are totally incompatible with the existence of a neurodegenerative process. These are the products of the brain of Professor Kennedy, not of the brain of Félicien Kabuga. Let us recall that contrary to Professor Mizi and Dr. Chuk, Professor Kennedy did not carry out any memory tests for a rather strange reason. He said to us, Mr. Kabuga declined. Mr. Kabuga did not wish to carry out the tests. It's striking to note that Félicien Kabuga was willing to do all of the tests required of him by all of the experts, Professor Razo, Professor Mézé, Dr. Bizoza, and Dr. Chuk, but not with Professor Kennedy, which prompts the question, did Professor Kennedy really try to convince Félicien Kabuga to carry out the tests? And as Professor Mézé said during examination, if he did try, he didn't try at great length. It should be noted as well that Professor Kennedy extrapolates fitness on the basis of anecdotal findings. For instance, he concludes that allegedly Félicien Kabuga had a high cognitive function because he made a joke. But as recalled by Professor Mizi on the 1st of June, and that is pages 65 and 66, even people suffering from severe dementia are capable of making jokes or of having playful conversations, and that proves nothing. Your Honours, Professor Kennedy refuses throughout his report to draw the slightest consequence from the disorders in Félicien Kabuga, abnormal MRI, memory loss, lack of concentration, etc. And when he is asked whether he might have an explanation to offer for his behavior, he says, "I don't have a scientific explanation." In answer to you expressly, Your Honour, as I said earlier, that Félicien Kabuga would be exaggerating his state of confusion. The other day, during the hearing, you said to me that Professor Kennedy's position would imply that he had nothing else to offer other than to suggest that Félicien Kabuga was allegedly malingering. I quote page 25 of the transcript on the 1st of June. Yes, indeed, Your Honour. It is the inevitable and logical consequence of the entire report and the examination of Professor Kennedy. He refuses to give a scientific explanation to the findings of all the experts and even to his own findings. So what are we left with? The only explanation that can be offered by Professor Kennedy is that Félicien Kabuga is allegedly malingering, which, as we have seen, is not a serious statement. But even if one tries to play down the grave nature of the disorders that Félicien Kabuga is suffering from and ignoring their source, Professor Kennedy has to deal with reality, and the reality is the very significant and obvious neurological impairments in the case of Mr. Kabuga and the numerous disorders that he shows. In the joint report of the 26th of May 2022, Professor Kennedy acknowledges, and I quote, that the mental health of Mr. Kabuga, including his cognitive function, fluctuates day after day. And I quote, that there is evidence of a vascular disease affecting the brain. I quote, of previous cerebrovascular accidents shown up by the MRI scan. And I quote, Félicien Kabuga is subject to episodes of delirium. And he says, and it is fundamental, that it's extremely difficult to determine the beginning and the end of the episodes of delirium. In other words, Your Honours, even if Professor Kennedy refuses to use the term unfit, he has to acknowledge that during such episodes, clearly Félicien Kabuga is not fit. What Professor Kennedy is selling to us is an alternating fitness. On one day, Félicien Kabuga would allegedly be fit, but the day after, he would be subject to an episode of delirium without anyone being able to predict its duration, its intensity, and even without anyone being able to determine with certainty the end of that so-called episode of delirium. Here again, it strikes us that such a position, which ignores pretty well all of the data in this case, including the proven existence of a neurodegenerative process, it strikes us that this is not terribly scientific. Particularly, Your Honours, if one were to assume that what Professor Kennedy is telling us were to have even a glimmer of scientific truth in it, we would have to find that his position would prevent any trial going ahead, in fact. Who will determine the beginning and the end of an episode of delirium? The defense, the chamber, the prosecutor, or a specialist attached specifically to Félicien Kabuga every day of the week? Professor Mizi, in analyzing the most recent reports of the UNDU doctor, and this is page 62 of her examination, noted the difficulty of an approach based on an alternating or fluctuating state of fitness. What does she say? She says that the reports of the UNDU doctor illustrate how an individual's cognitive functioning and mental state can fluctuate, not just month by month, but sometimes from day to day, week by week, and this in the absence of an underlying crisis. So it's very simple. It is the neurodegenerative process. And she adds that these fluctuations would be one of the problems that the chamber would be facing if the trial were to go ahead. Mr. Kabuga may be able to communicate part of the day and would be in a completely different state for the remainder of the day. In other words, it would not be possible to interact with him other than at totally unpredictable moments. And to come back to the position of Professor Kennedy, Félicien Kabuga, would he not be exhausted after these episodes of so-called delirium and unable to take part in his defense? Could we move into private session, please, Your Honor?
We're back in open session. Thank you.
Thank you, Your Honor. Professor Kennedy is so unsure of his own position that he proposes there be accommodation so that Félicien Kabuga can participate in the proceedings. I won't run through the accommodations, but I would like to make a number of comments. You will note, first of all, that if Félicien Kabuga were fit, there would be no need for these accommodations, or for most of them, at least. You will also note that these accommodations show, in actual fact, the unfitness of Félicien Kabuga, the unfitness thereof. Your Honours, if his memory worked, why would it be necessary on a continuous basis during the hearing to have somebody with him to remind him of what's going on? If his ability to understand were not affected, why would it be necessary to send in advance to his defense team so that it could prepare answers the questions that the prosecutor would intend to put to Félicien Kabuga in the context of cross-examination? If his ability to process information were not affected, why should the procedure need to be modified in order to break it down into chunks, making it almost indigestible through this breakdown to little chunks. So you can see that Professor Kennedy seems never to conceive for 1 second for the fact that Félicien Kabuga might be able to stand trial in its current state. Now, Professor Kennedy has acknowledged his total ignorance of what is involved in international criminal proceedings. He doesn't know what an examination in chief is, nor a cross-examination. He thinks that you can cross-examine by submitting questions in advance in writing. He knows nothing as regards the dynamics between a witness and the cross-examiner. In a nutshell, then, based on an incorrect vision of the proceedings and a total lack of understanding of the necessary balance in the proceedings and the rights of the defense and the equitable nature of the proceedings, all of his proposals are impracticable. Let me give you an example. When he proposes that there just be one subject per sequence, that is impossible. When a witness appears, he or she presents the entirety of testimony, speaking about everything that he or she has to say. If we were to go along with Professor Kennedy, we'd have a witness coming on one day to talk about what he or she knows, for instance, about the RTLM. And then 3 months later, they'd be called back to talk about something else. And another 3 months down the road, something else. And each time round, there would be an examination in chief and a cross-examination that would be broken down and without any overall consistency. That has no point, it has no sense, and it reveals a total lack of understanding of what testimony is, of what examination in chief and cross-examination are, and at the end of the day, a total lack of understanding of criminal proceedings. Professor Kennedy approaches things theoretically, but, Your Honours, we know that the balance of proceedings has to be found at every single moment. We know that fairness depends on the way in which the parties in the chamber, in practical terms, deal with the problems posed to them on a daily basis. So this is what Professor Kennedy is proposing. A fitness to stand trial between two crises of delirium. It's he who says this, which, if we follow him, could occur at any given moment. And even more, this fitness is subject to a condition, which is the total turning on its head of the proceedings and the vanishing of its equitable nature. Believing that he was convincing you, Professor Kennedy adds that Félicien Kabuga understands in the evening what has been said to him during the day. That's page 70 of the transcript from the 31st of May. In other words, allegedly, he would understand the statements of a witness, or rather he would only understand this several hours after the witness had spoken. So, fitness in an alternating or fluctuating fashion, subject to conditions, fitness that would be offset in time. What are we talking about? Are we talking about fitness? There is no meaning to this. And you will note also that Professor Mizi doesn't believe for one instant that there's any value in these accommodations, and I refer you to her report of the 25th of May 2022. Your Honor, there's something I would like to say, and I think it's important, about the other expert called by the prosecutor, which is the Rwandan expert. So, a few words about the Rwandan expert, Your Honours. The prosecutor's expert turned out to be a militant of the Rwandan Popular Front, and proud to acknowledge that. He contradicts himself as regards his own experience. In his CV, he doesn't even mention any forensic expertise experience. He explained to us during the hearing that he didn't feel that there was any value in pointing this out, whereas we're talking about being appointed during legal proceedings as a forensic expert. And in his CV, he mentions a lengthy list of skills and competence that are irrelevant, for example, pediatrics. What is more, he allegedly told the prosecutor that he carried out some 20 forensic expert assessments per annum. And then during the hearing, he said he'd only carried out around 30 throughout his entire career. And he's not sure that these expert reports have any bearing on what he's been asked to do here, as he presented himself during the hearing as a PTSD specialist. As for his methodology, he was unable during the hearing, he was unable to give specifics as regards his methodology. He was unable to give more than a couple of examples of questions that he allegedly put to Félicien Kabuga during a 2-hour interview. And the expert had to refer to a written document to give examples of questions of the mini-mental state test, whereas he claimed to be a real expert on the matter. He also considered that Wikipedia was a reliable source in the context of legal proceedings to describe the charges against Félicien Kabuga, charges that are not even in the indictment. So, in these extremely suspicious conditions, the defense would put to the chamber that it would be wise to set aside the conclusions of this so-called expert. And let me say something now about Arusha, and that will bring me to the end, Your Honours. I shall be very short on Arusha. There is unanimity. All of the experts advise against Félicien Kabuga being detained in Arusha. All, including the Rwandan expert and including Professor Razo. I'd like to recall what the registry said to us on the 16th of October 2020. There are no cardiologists nor rheumatologists in Arusha or in Moshi. If Félicien Kabuga were to require the services of such specialists, he would have to be transferred to Dar es Salaam, which is at 640 kilometers from Arusha, 10 hours by road, 1 hour by plane, or to Nairobi in Kenya, 270 kilometers away, 5 hours by road, 1 hour by plane. In this report, it says, and I quote, if Mr. Kabuga were to require urgent care that could not be provided in Arusha, he would have to be transferred to Nairobi, end of quotation. Nairobi, that's in a different country. And you know that the treatment provided in Arusha is far from the sort of care offered in The Hague. If, Your Honours, Mr. Kabuga were to be deemed fit to stand trial, sending him to Arusha would be a death penalty. By way of conclusion, Your Honours, you have on the one hand the report and the examination of Professor Mizi, the reports of Dr. Chuk, which are sound medical and scientific demonstrations based on objective elements, which are the medical elements on file, and they're all going along the same direction. In other words, that Félicien Kabuga is unfit. On the other hand, you have the contradictory statements of Professor Kennedy, who was trying to sell you the idea of a deferred fitness, an alternating, fluctuating situation, provided the proceedings were totally transformed. Your Honours, that brings me to the end of my submissions.
Thank you, Maître Altit. I think in view of the hour, it would be appropriate for us to have a break to allow everyone to restore comfort and concentration. So we'll adjourn for, at the most, just over 15 minutes until 11:45. So the court will resume at 11:45.
All rise, voulez-vous le verre? All rise, voulez-vous le verre? Please be seated.
Maître Altit, there is one small point I would like to clarify with you. It may be a matter for the interpreter, but you may be able to clarify it first of all. In referring to Dr. Bezosa, the English translation of what you said was that he was a militant of the Rwanda Patriotic Front. I don't know if that has changed, but that's how it came. Yes, it's still militant of the Rwandan Popular Front. In the evidence, when he gave it, it was translated as a member of the Rwandan Popular Front. Now, I understand that in French there may be a closer connection between these two nouns, member and militant. Can you clarify what is the appropriate English for the submission you made today?
Oui, monsieur.
Mr. Altit, sure, Your Honor.
Oui, Monsieur le Président, vous avez tout à
Your Honor, you're absolutely right. When he came, Bizu's doctor introduced himself in that way, and I quote, I will do a French translation on the base of the transcript. I'm a member of the Rwandan Patriotic Front. I'm proud of this. I worked with them, with the Rwandan Patriotic Front. And then he says other things. But the way he presents this is the way in which we could qualify him. We could qualify him as a militant in French, and even of an active militant.
Thank you, Maitre Altit. Mr. Elderkin, do you have a role in this?
Just that I've seen the terminology both in the French and translation in other materials, I believe, have been officially translated, and the word militant in French has been translated to activist. So militant to militant in English is not quite the same as militant to activist, but it may well be, if a question for the chamber, it would be LSS who would have possibly the final answer.
Yeah, well, thank you for that intervention, but your explanation, Maitre Altit, answers the particular question that concerned me. May I, speaking for myself, thank you for the submission you've made, and move on now to the role of the prosecution in this stage of the proceedings, and give the floor to Mr. Elderkin.
Your Honours, I would actually like to start with a very short period in private session, as I would like to show a short 3.5-minute extract from the February status conference. The section that the case manager has lined up is from 49 minutes 14 seconds through 52 minutes 50 seconds, and it came from private session in that status conference, hence my request now.
So you wish to present evidence?
I believe this evidence already, for the purposes of the hearing, is considered to be in the record. It was one of the court's prior sittings when Your Honour was sitting alone, and it would help to frame an understanding of how we are presenting Mr. Kabuga's fitness based on his displayed competences.
Maitre Altit, what's your submission in relation to that?
Mr. Altit, we do not oppose this request, Your Honor.
Very well, we shall go into private session.
We're back in open session.
Thank you. Mr. Eldekin, remind me of the date of that status conference?
That was the 3rd of February, Your Honour. Of this year.
Very well, thank you. Please continue.
Your Honours, on the balance of probabilities, the evidence before you is that Mr. Kabuga is fit. The defence have not met their burden. What matters is what Mr. Kabuga is capable of doing. As things are today, he is capable of meaningfully participating in the proceedings, and it is in the interests of justice for there to be a trial. Holding a trial with appropriate accommodations in place respects Mr. Kabuga's rights. It respects also the rights of others with vested interests in the case, notably survivors and relatives of victims of the Rwandan genocide. And it respects the common interest for the gravest of international crimes to be prosecuted in all but the most exceptional circumstances. To be clear, the prosecution accepts that Mr. Kabuga is a vulnerable, elderly man. And the time may come when he is no longer fit to stand trial. But that time is not now. The accommodations to adapt trial procedures to assist Mr. Kabuga are important. They do not cure unfitness, rather, they reflect that fitness has to be assessed within the appropriate framework that makes an international criminal trial possible in the face of all of the complexities inherent in such proceedings. Accommodations are enshrined in the rules of the mechanism, most notably an accused's right to be represented by counsel, and at a simpler level, for there to be interpretation of the proceedings into the language of the accused. Accommodations are part of the system. In view of Mr. Kabuga's age and vulnerability, additional, indeed novel, accommodations can and should be made. That's how justice gets to be done in cases such as those still being prosecuted, for example, in Germany, in relation to charges from the time of the Second World War. If proceedings at the domestic level can be adapted appropriately, that must also be possible at the international level. And your honours will recall that Professor Kennedy in particular has made a number of practical recommendations that you may wish to consider. A few words on the applicable standard according to which Mr. Kabuga's fitness is to be assessed. The fitness standard set out by the ICTY Appeals Chamber in the Strugar appeal judgment has been approved in other international courts and tribunals and is the applicable standard. First, the assessment is a common sense, judicial assessment. Second, the test is whether, on the balance of probabilities, the accused can meaningfully participate in the proceedings. The burden is on the party raising a fitness challenge to make their case. The standard is not something higher, as clarified during the cross-examination of Professor Meze, who misstated the standard in her report. Meaningful participation is not a high threshold. Courts around the world try cases against accused persons with cognitive impairments, accommodating and protecting those accused by allowing for their representation by counsel. Meaningful participation should be determined at a practical level, taking into account the accommodations and protections available. It is not a hypothetical question of testing whether the accused could have a fair trial absent such protections.
Can you clarify the point you're making about the role of counsel or the very involvement of counsel? You say that courts around the world try cases against accused with cognitive impairments, accommodating and protecting these accused by allowing for their representation by counsel. Are you saying that the very fact of representation by counsel is somehow or other an accommodation for persons with cognitive impairments?
Your Honour, I want to be careful not to suggest that there is a cure in terms of the fitness standard where representation or any other accommodation somehow can lift an incompetent, unfit accused out of that state. But as Your Honour's heard, particularly during the examination process last week, there were a lot of suggestions put to the experts as to what role an accused supposedly should play in proceedings, and particularly before this institution in very complex proceedings. And I want to dispel any suggestion that much of the tasks that indeed should be undertaken by counsel actually would fall on the accused, and therefore an accused who cannot do all the sorts of things that belong to counsel should be declared unfit on that basis.
Thank you. That clarifies the point for me. Thank you.
Indeed, my point on the page is to turn to an understanding of what role belongs to defence counsel, what is it that is asked of an accused in the proceedings. The role of defence counsel includes to provide an appropriate interface between the complexities of the proceedings, including, for example, the volume of evidence involved, and the accused, who is not expected to be as able as counsel to assimilate and navigate the full body of evidentiary material and the legal framework of the case. And this is from the Strugar appeals judgment at paragraph 60. An accused represented by counsel cannot be expected to have the same understanding of the material related to his case as a qualified and experienced lawyer. Even persons in good physical and mental health, but without advanced legal education and relevant skills, require considerable legal assistance especially in cases of such complex legal and factual nature as those brought before the tribunal. That's the end of the quote. The appeals chamber, again from the ICTY, in the Popovich et al. Proceedings, and this is from a decision on a request by accused Guevara to terminate proceedings, stated, processing the wealth of complex information inherent in international criminal proceedings is the role of defense counsel in order to advise their clients. And I'm spending time on this, Your Honours, because it seemed that at times during the defence's examination of the experts, they were reversing the roles of counsel and of the accused. So during the questioning by Maitre Altit of Professor Kennedy, and this is from the 31st of May transcript, page 57, it was suggested that the accused would need to be following what the witness is saying, understanding what the witness is saying, understanding all of the details, the ins and outs, understanding the reasons why the witness is saying what he or she is saying, and also knowing whether the witness is telling the truth or not, and consequently knowing why or trying to understand the reasons therefore. So it's an exercise of extreme concentration that an accused person has to show, and summarizing things, those to explain to counsel, the defense team, what has occurred in his or her opinion. End of the quote. The prosecution submits that this is not what is required of an accused, but rather what counsel must be doing on behalf of their client.
Now, I can see, Mr. Elderkin, that you have some support for that submission, but I note that it seems to fly in the face of the insistence, the persistent insistence of international courts upon the right of the individual accused to represent himself, no matter how complex the case may be. How do you marry these two essential elements?
Your Honour, the right is the right, and indeed self-representation is enshrined, allowed before the mechanism, previously before the Rwanda and Yugoslavia tribunals. In practice, the majority of accused do choose to take the advice of counsel. Those who do not, accommodations again are made. So it would be, I think, veering into a hypothetical situation to determine what would we be considering if Mr. Kabuga were insisting on self-representation in these proceedings and he was sitting across the courtroom rather than the defense team. But again, I acknowledge indeed that it is enshrined and I don't seek to suggest that there is not that right. It's simply one that is not in play in this case and today.
Thank you.
And happily, I gave myself numbered points, so I think I'm at 4 here in relation to the standard. Fourth, the Chamber has seen in the experts' reports and heard in their testimony the phrase, fitness is a dynamic concept. Everybody has good days and bad days. A person of Mr. Kabuga's age and state of health more evidently so. The assessment of fitness does not relate to an accused's bad days, but to their baseline state, how they function when they are not fatigued or suffering from the effects of a temporary infection, for example. It would not be in the interests of justice to determine Mr. Kabuga's fitness to stand trial based on a time when his cognitive capabilities were diminished, for example, by the temporary after effects of surgery or illness, or when he's simply fatigued. Fifth, the assessment of fitness is not prospective. Mr. Kabuga should not be deemed unfit today because there is a risk that he may in future suffer cognitive decline, rendering him unable to meaningfully participate in proceedings. A view of how Mr. Kabuga will be in 6 months, 1 year, or 2 years' time may well be relevant for trial management and planning purposes, but it should not feature in the assessment of his fitness. This is important because much of what Professor Meze had to say about Mr. Kabuga's fitness concerned her views on his future trajectory, and indeed, much of the defense's cross-examination of Professor Kennedy also focused on this subject. But that is not relevant, as I say, to the fitness determination that you are tasked with making today. To continue the point about the assessment not being prospective, the question about whether Mr. Kabuga is capable of testifying in his own defense should not be considered at the time, should be considered at the time when he may exercise that right, and not before. The prosecution's case comes first, and it would be premature to determine that Mr. Kabuga is unfit to stand trial as of today based on a concern as to whether he is capable of undergoing the common question and answer process of witness examination much later in the proceedings. That question might indeed be ripe when it is time for the defense case, if he should choose to exercise his right to testify in his own defense. But it should not be preemptively determinative of whether a trial can start and proceed up to that point. I'd add that this question should be considered also in light of the possible accommodations, such as using written questions, or even the possibility to proceed without cross-examination. Sixth, the actual medical diagnosis of Mr. Kabuga's condition is not of direct relevance to the determination of his fitness to stand trial. Pavle Strugar, the accused in the case that gave rise to the governing jurisprudence concerning fitness, was accepted by the trial chamber to have been properly diagnosed with Alzheimer's dementia. However, the diagnosis was not determinative of his fitness. What mattered then, as it matters now, is the accused's functional capacity to meaningfully participate in his trial, not any label given to describe his condition. And from paragraph 61 of the Strugar appeals judgment, I quote, "Medical diagnoses, no matter how many, do not suffice to assess a person's competency to stand trial."
Now, going back to your immediately preceding point, if my memory is correct, the final element in the various capacities that require to be absent or required to be present for the accused to be fit for trial is the ability to give evidence in his own defense. You're saying that should really be detached from the assessment. And if that's right, is there any authority to support that?
Your Honour, I'm proposing it as the logic as that I'm advancing, which is fitness is assessed in real time. So again, if I'm right that there is not a prospective assessment, the only time when there would be clarity on the accused's fitness, capability, let's call it, because I think the capacity or capability is the terminology used in relation to the Strugar non-exhaustive list, is at the time when the accused would be coming to exercise that right. And I would say that, as far as I recall from the list of capabilities or capacities in Strugar, uniquely the capacity to give a statement, testify in his own defence, is the only one that is effectively sequenced away from the others. Obviously, one could not start a trial with an accused unfit to instruct counsel, unfit to understand the evidence, unfit to enter a plea, but those are things that are actions for now. The only action that lies in the future would be to testify.
What would you say was the situation if it was clear at this stage that an accused could not conceivably, as matters stood, give evidence in his own defence? You would say, nevertheless, the trial should start if otherwise the test was satisfied. And you must envisage circumstances where that could give rise to massive injustice.
I would agree with Your Honour. If it were clear, as of now, then no, the test is then not fulfilled, that he is fit. But I would question in what way one could make that specific sub-determination. It's clear he could not give evidence in his own case at this stage, particularly before potentially necessary or possible accommodations had been made. So with the functionality required to give evidence were a capacity to be able to answer pre-prepared questions, not face cross-examination, without knowing how the trial would unfold, or without potentially an early judicial ruling or an agreement even by the prosecution saying, we would not cross-examine, then the quite technical questions in play as to what the accused could or could not do would not be fully aired. But in a simple word, clear. Were it clear now, then no, I wouldn't argue at all with Your Honour.
So I think I may have expressed some doubt to Professor Kennedy about the notion of prepared written questions in cross-examination. But it sounds as though you're not sceptical about that as a possibility.
As the party who would have the normal right to cross-examine, again, we believe our case can be made without necessarily having to run it through a cross-examination of the accused. We believe that the evidence we will present through our normal witnesses, through other evidentiary materials, would suffice. And if it were to be a swing point that would determine whether the accused were fit or otherwise, I believe that we would be in a position to make all possible accommodations so that that right could be respected without putting the accused in a situation that the bench understood he would be incapable of exercising his right.
Very well, please proceed.
Your Honours, the foregoing is the framework within which the prosecution submits Mr. Kabuga's fitness must be assessed. I'll turn now to the evidence that we have available to feed into that assessment. Each of the medical experts has given their opinion on fitness in response to the questions asked of them. In addition, contained within their reports and testimony are a large number of observations concerning their interactions with Mr. Kabuga. Across the various assessments, as well as during the status conferences, particularly of February and May of this year, Mr. Kabuga has spoken of his personal history, presented arguments, as we've seen on the short clip, presented arguments relating to his defence and representation, made requests concerning the change of his representation, and articulated reasons for such requests, told jokes, and spoken of his awareness of the ongoing assessment of his capabilities. The clip that I played earlier is, of course, just one example, but the evidence from the complete body of observational material, those recordings of the status conferences, the medical reports from the UNDU, and the reports and testimony of the medical experts, demonstrates across an extended period of review that when Mr. Kabuga's physical health is good, when he is properly rested, he can concentrate, communicate, recall relevant facts and events, make choices, and learn and manipulate new information. Taken together, all of these elements form a picture of sufficient cognitive capability to allow meaningful participation. There's no getting around the fundamental difference in opinion between the views the Chamber has read and heard from Professor Meze and the opinions of the other specialist experts, as well as of the medical team treating Mr. Kabuga. Professor Meze alone, I believe, and I hope my understanding of Dr. Chuk's report is correct, but with that caveat, I believe Meze is alone amongst all of the medical professionals who have seen Mr. Kabuga to arrive at a diagnosis of dementia. There is no diagnosis of dementia in any of the prior medical records to which Professor Meze had access. Nevertheless, she was adamant during her testimony, stating, "I am certain in my diagnosis." And that's from the 1st of June transcript, page 79. This certainty appears to me misplaced and beside the point. Professor Meze, alongside Professor Kennedy, agreed in their joint statement that cognitive function, not any diagnostic label, was the key question. That's from page 2 of the joint statement. However, Professor Meze nevertheless chose to advance her dementia diagnosis and put it at the center of her evidence relating to Mr. Kabuga's functional capabilities. Those things, the prosecution say, are what matter. This creates a circularity in her reasoning, according to which she arrives at the diagnosis based on an assessment of Mr. Kabuga's cognitive function, then uses the diagnosis to propose that Mr. Kabuga's cognitive functions are lacking because he suffers from the condition that she has diagnosed. If Your Honours would look at paragraph 66 of her report, she dismisses the importance of the precise diagnosis, but then immediately says that what matters more is the effect his brain disease has on core aspects of his cognitive functioning. Yet, brain disease is the diagnosis she made, albeit stated in more general terms. So Professor Meze says that diagnosis doesn't matter, but in the same breath, she goes on to say that it does. This contrasts with Professor Kennedy's approach. His assessment was founded on a broad-ranging assimilation of observations concerning Mr. Kabuga's real-world behaviour, including information from many of those in regular contact with Mr. Kabuga at the United Nations Detention Unit and the prison medical facility. Professor Kennedy isn't looking for a diagnosis, but at cognitive function, irrespective of any underlying medical diagnosis, which is exactly what the Strugar jurisprudence requires. Aside from the distance between Professor Mézé's position and the positions of all the other specialists and treating staff, her evidence taken on its own raises questions and is problematic in a number of ways. First, Professor Mézé's methodology is questionable in terms of the sources that she chose and relied upon. According to her testimony, Professor Mézé's first step in her assessment of Mr. Kabuga was to read into the medical file. Well, Mr. Kabuga's medical history, as provided to Professor Mézé, contained no diagnosis of dementia, nor any history of repeated strokes. Terminology is important here. Mr. Kabuga had experienced TIAs, but TIAs are transient and different from strokes. Professor Mézé also spoke to Dr. Falca, and she interviewed Mr. Kabuga on the 17th of January 2022. That interview included the mini mental state examination that was explored in some detail during Professor Mézé's cross-examination. She testified that it was at this stage of her assessment that she formed her first opinion concerning a dementia diagnosis. And that's from the 1st of June transcript at page 49. After that, and she gave two different versions of this during her testimony, Professor Mézé either spoke to Mr. Kabuga's daughter and then received the radiologist's report of Mr. Kabuga's MRI scan, translated into English by Dr. Falca, or vice versa. So either it was the conversation with the daughter, then the MRI scan, or the MRI scan followed by the conversation. It doesn't particularly matter. At first blush, this gives the impression that Professor Mézé's diagnosis was broadly based. But the core of the evidence used by Professor Mézé is much narrower. At paragraph 64 of her report, she stated that the MRI conducted recently, in combination with his scoring on the mini mental state, however, is highly suggestive of dementia, as is the additional information provided by Mr. Kabuga's daughter. Now, as much of what Professor Mézé's evidence about Mr. Kabuga's functional capacities flowed from that diagnosis, it pays to closely consider how strong are those three identified foundations. Starting with the mini mental state examination, this is problematic, not only because, as Professor Kennedy explained, it is intended as a screening tool for clinical practice. And I refer to transcript of the 31st of May at page 8. But also because in any event, the test is not validated for people of Mr. Kabuga's lower educational level and Professor Meze could not confirm that it is validated for use with Kinyarwanda speakers. Despite providing a caution regarding level of education in her report, and that's Meze's report at paragraph 30, I also note that Mr. Kabuga indeed told Professor Meze that he had no schooling at all, as indicated in her report at paragraph 3 of the background section. Professor Meze testified as to her belief that the examination has validity because Mr. Kabuga's scoring, when she administered the test, matched her clinical observations. That's from the 1st of June, transcript page 46. Professor Meze also testified that a person's cultural background and language would not necessarily be relevant to their performance on cognitive tests generally, or on the mini-mental state examination in particular. That's the 1st of June, transcript page 46. And from the same transcript page, she testified that there are a number of questions within the assessment that I think are invariable across cultures, across language barriers, and that actually give you objective evidence of how that person is able to conduct those functions. Your Honours, the prosecution has loaded into e-court one paper from a British medical journal publication called Practical Neurology, which has not been used with any of the witnesses. If Your Honours would allow me to quote from it and in your own time consider whether this would be considered as admissible, for example, as equivalent from the bar table,
Monsieur le Président.
I will go ahead. If it's clear that that would be ruled against, then I won't quote from that paper.
Maître Altit.
Merci, Monsieur le Président.
Thank you, Your Honour. We object. It's new evidence.
Well, so far you haven't tried to present any justification for doing this, and I think you would have to before we could consider admitting it.
Your Honours, I submit that the proposal for this particular item flows from the examination that took place last week and consideration of the most useful body of material that would assist Your Honours in these proceedings. The document, as I say, in terms of a rules basis for admission, Your Honours do have obviously wide leeway under normal trial proceedings to consider submissions for admission from the bar table. I would submit that in terms of what this potential item is worth, it on its face comes from a reputable publication. It stands for a proposition that would be within the normal range of opinions in the scientific community. Otherwise, I would simply refer Your Honours, if it's not admitted, to consider Professor Kennedy's observations as to the limitations of the mini-mental state examination.
I think we should settle for Professor Kennedy's view. Yeah, we do not consider it appropriate that reference should be made to this document at this stage, and we reject your proposal. Please continue.
Turning now to the second of those three foundations, Professor Meze relied heavily on information that she obtained from Mr. Kabuga's daughter, Bernadette Uwa Maria, indeed devoting 17 paragraphs of her 91-paragraph report to that information. Nowhere in her report does Professor Meze provide any assessment of the reliability of this information. She described Mr. Kabuga's daughter as a so-called independent informant, and during her testimony, Professor Meze confirmed that she found the interview with Ms. Uwa Maria very, very helpful. That's from the 1st of June transcript, page 19. Professor Meze also refers to a letter sent by a Dr. Paulin Murayi, who is Kabuga's son-in-law, again treating the information contained therein uncritically. Professor Meze confirmed on examination that when she spoke to Ms. Uwa Maria, she told her that she had been asked by the chamber to assess Mr. Kabuga's mental state. That was a question indeed Your Honour posed, and it's at 1st of June transcript, page 78. I don't believe so, Your Honour.
Very well. Please continue.
Your Honours, the third of those foundations, the MRI scan. The Chamber heard from Professor Kennedy about the limitations of scans showing brain anatomy in assessing brain function. That's from 31st of May transcript, page 13. The position taken by Professors Meze and Kennedy in their joint statement in relation to the MRI scan is that which actually Maître Altit this morning read into the record, and interestingly is rather more restrained than the account Professor Meze gave during her testimony. The reference in the joint statement from page 3 was in terms as follows: "We agree that there is evidence of vascular disease affecting the brain and previous cerebrovascular accidents, evidence on the MRI by patchy, ischemic, and other age-related changes to Mr. Kabuga's brain." As the Chamber heard during Professor Meze's testimony, her views of what the MRI scan showed were much stronger than the view expressed in that joint statement. I would submit to the point of appearing quite defensive. Given that Professor Meze didn't look at the images from the MRI, the English translation of the radiographer's report takes on particular importance. Professor Meze received her translation from Dr. Falke. The registry has the original report in Dutch and has provided its official translation in English. And that's in e-court as well, for access to the parties and to the trial chamber. There is a fundamental difference between the two translations of certain key words. Whereas Dr. Falke's translation, as relied on by Professor Meze, refers to severe, degenerative, parenchymal loss of both hemispheres, and that's from paragraph 53 of Professor Meze's report. The official translation of the radiological report at the same point reads, "Considerable generalized parenchymal loss of both hemispheres." And that from the official translation is on page 2. The Chamber may prefer the translation provided by the official service to that provided by Dr. Falke, and may wish to consider how such wording could be susceptible to a different interpretation than that arrived at by Professor Meze. That's methodology. Second, briefly, Professor Meze acknowledged that she applied the wrong standard of fitness in her assessment and report. I do note that despite having applied the wrong standard, during my cross-examination, Professor Meze asserted that even applying the applicable standard, her views would be unchanged. And that's from the 1st of June at transcript pages 66 through, I think, 69. But the lack of care in the wording she used points to what Professor Meze did acknowledge also during her cross-examination, that her work had been rushed. And that's from the 1st of June, transcript page 38. A third problem. Professor Meze's focus on her preferred diagnosis without properly assessing other possibilities is further revealed by her admission that she did not perform any tests for malingering. Transcript references 1st of June at page 59. Rather, she dismissed the possibility out of hand, expressing the view that maintaining a deceptive posture or modifying his behavior over a sustained period would not be possible. Again, that's 1st of June, transcript at page 24. Yet, And again, this was elicited, despite my submission saying that it's within the court's record and knowledge as to Mr. Kabuga's fugitive years. Professor Meze did confirm that she learnt that he'd been in hiding when she conversed with the daughter. And so I would submit on that basis that we know that this is exactly what Mr. Kabuga managed over an extended period of many years up to his arrest, and even including after the time in 2019 when, upon the account of his daughter at least, he allegedly suffered a mental decline. A fourth problem, potentially, with Professor Meze's report, and this is that, according to information provided to Professor Kennedy by staff at the prison medical facility, they had the impression that Mr. Kabuga is much more difficult in performing requests for women. That's from Professor Kennedy's report at paragraph 53.3. The Chamber may wish to consider whether this apparent bias may have adversely affected Professor Meze's interaction with Mr. Kabuga. Lastly, it may be banal, but still worth noting that the conditions in which Professor Meze undertook her task may be part of the explanation for the problems that I have outlined. Her assessment took place at the height of the winter wave of the COVID-19 pandemic, and she admitted during her examination that she had, as I have said, limited time available to complete her assessment and reporting task. That's 1st of June transcript, pages 38 to 39. She spent 2.5 hours interviewing Mr. Kabuga in one sitting, and indeed expressed surprise that Mr. Kabuga could manage that length of meeting without a break. That's the 1st of June transcript, page 39. She also noted that Mr. Kabuga wore a mask for most of the interview and that there was a glass screen in place between her and Mr. Kabuga. Again, the 1st of June transcript, page 38. By contrast, Professor Kennedy split his time with Mr. Kabuga into 2 sessions of about an hour or longer across 2 days. See the transcript from the 31st of May, page 54. This may be relevant to the differences in behavior and cognitive ability observed by the 2 experts. Professor Kennedy's description of the COVID-19 measures in place when he met Mr. Kabuga is simply of 2 tables being pushed together to increase the distance between them. There is no mention in his report of any screen or masks being worn. And for the 2 tables being pushed together, that's from his report at paragraph 54.1. Overall, the supposedly triangulated basis for Professor Meze's opinion is insufficient. When I referred Professor Meze to paragraph 64 of her report and asked her whether she considered all 3 of the sources mentioned therein as forming the basis of her dementia diagnosis to be equally reliable, she answered, "Well, the MRI is undoubtedly objective and reliable. The information from his daughter, I thought, was again very helpful in just allowing you to pinpoint, if you like, a time where this process may have begun. So that was helpful. I think they're all reliable. You might put a slightly different weight on all of them, and of course what I've missed out there is, of course, the clinical assessments and the discussions with Mr. Falker and the medical records and his history that have preceded that." And that's from the 1st of June transcript, page 52. Your Honours, as I have outlined, the MRI information is not undoubtedly objective and reliable. None of the other experts found that dementia was indicated. In addition, as again, I've submitted the translation provided to Professor Meze, which is the only information she received from the MRI scan of this year, is questionable in an important respect. The mini-mental state examination has not been validated for use with somebody like Mr. Kabuga, and does not do the work that Professor Meze needs it to, either in reliably supporting her diagnosis. The information provided by Mr. Kabuga's daughter, also, as submitted, cannot reliably support her diagnosis. Professor Meze added in as sources for her diagnosis the broader medical file, clinical assessments, and discussions with Dr. Falker. But yet again, none of these sources contain or confirm a dementia diagnosis. Sorry, Your Honour.
Yes. Mr. Elderkin, what do you make of the additional report that Professor Matachi Rasso communicated on the 15th of February following his review of the MRI report? He said he had read the psychiatric report of Professor Meze and described it as complete and complementary to my report of November 2021. He then went on to say the diagnosis of dementia is based on clinical findings. The radiological findings give information on the nature of the process.
Your Honour, my reading of that additional report or statement from Professor Matache Rasso was that he had indeed, in his November report of 2021, I believe, suggested that it would be appropriate to seek expert psychiatric assessment of Mr. Kabuga. And I read his submission from February of 2022 as simply semantically referencing that indeed he had provided a gerontological report, and it would indeed be complementary and, on his reading, a complete report provided by Professor Meze. I don't read Professor Matache Rasso as adopting the finding of dementia, and the second part of his short communication of February sets out what, again upon my reading, is simply a general description of what a dementia diagnosis is founded upon, what it is based upon. I do note that obviously Professor Matache Rasso was not given the chance to comment on the report of Professor Kennedy, so I won't speculate as to how he would have addressed that, whether in similar terms or otherwise.
Right, thank you.
So finally, as Professor Meze noted, there were a set of additional sources that she says also played into her diagnosis. And for my comments on this, I'd ask if we may go into private session briefly.
Private session. Please continue.
The prosecution submits that Professor Mezet's report is sufficiently problematic that even given the explanations she provided during her testimony, it cannot be preferred to that of Professor Kennedy. And so turning to Professor Kennedy's evidence, I invite the chamber actually to heed the words of Professor Mezet, who at the 1st of June transcript page 80 said, "I don't want to criticize other doctors, and there are always going to be differences, but I think that the more information you have, the more confident you can be in coming to a diagnosis." I would invite the chamber to consider the range of information Professor Kennedy relied upon to form his opinion, by contrast to the information relied upon by Professor Mezet. Professor Kennedy reviewed the medical file. He had extensive consultations with the UNDU medical officer and the UNDU deputy medical officer, the UNDU physiotherapist, 2 UNDU detention officers, the general practitioner from the prison hospital, and a senior detention officer from there, interpreter, a UNDU nurse, a prison hospital nurse, and in addition, he watched the videotape recordings of the hearings of the 21st of June of 2021, the 6th of October 2021, and 3rd of February 2022, and read the transcripts of those hearings. And that's set out at Professor Kennedy's report at paragraph 1.9. I would also refer your honours to Professor Kennedy's long account of the variety of behaviour that he observed or was told about by non-partisan sources concerning Mr. Kabuga. There are many common sense examples in Professor Kennedy's report of Mr. Kabuga doing things such as telling sophisticated jokes. And having heard the defence this morning question the significance of this particular observation, I note that Professor Kennedy was interested specifically in the relevance to the circumstances they were in and the sophistication of that joke, not the mere fact of it being told. His observation of Mr. Kabuga recounting his personal story, engaging in discussion about television and current news from Ukraine, even learning some Dutch. If Mr. Kabuga can do these things and more, he can meaningfully participate in a trial supported by counsel. Professor Kennedy did not suggest that Mr. Kabuga is the picture of perfect health or that he has no cognitive difficulties. He explained that Mr. Kabuga's thought processes are slow. That's from the 31st of May, transcript page 70. And he would need extensive accommodations in order for him to go through the trial process. Professor Kennedy accepts that Mr. Kabuga's condition may change during the coming months and years. However, as of today, his conclusion is that Mr. Kabuga can meaningfully participate and so is fit to stand trial. His conclusion is based on a broad body of evidence gathered from a range of sources who, apart from Mr. Kabuga himself, are not invested in the outcome of the assessment process. While the views of Professors Mezet and Kennedy have been placed at the centre of this process of determining Mr. Kabuga's fitness, the consistency of views of Professor Metache-Rasso and Dr. Bizoza are material. Professor Metache-Rasso, the only gerontologist to have provided expertise, found Mr. Kabuga fit to stand trial. In his report dating only 2 months prior to that of Professor Mezet's, he explicitly considered and rejected the possibility of dementia. He stated that we have to keep in mind that the cognitive decline has not yet the characteristics of a dementia. And that's from his November report of 2021 under the heading Considerations. The information available to Professor Matache Rasso at the time of his report in November 2021 was substantially the same as that available to Professor Meze 2 months later. The records available to Professor Matache Rasso included the information that Mr. Kabuga had previously suffered from TIAs, transient ischemic attacks, which, as the name indicates, are transient episodes. Again, I reiterate, not the same as strokes. This history, taken together with all the other information available to him, did not lead Professor Matache Rasso to diagnose dementia. There is no indication in the medical records that Mr. Kabuga suffered any additional strokes or significant events that could have led to his condition deteriorating so significantly between the time of Professor Matache Rasso's assessment and the time of Professor Meze's assessment. And in answer to your question, Your Honour, I've already referred to the subsequent short additional report of Professor Matache Rasso. Now Dr. Bizoza. He, unique amongst the experts in being able to converse without...
Just give me a moment. Mr. Elderkin, can you help me with how long you might be now?
10 to 15 minutes.
Can the interpreters tell me, please, whether that's okay or whether we need to break at this point?
Your Honour, I think that's perfectly fine for us as well.
I'm told by my colleagues I may even do it in 5.
All right, I'll give you 5.
So Dr. Bizoza, the reference to his ability to converse without need for interpretation is from the 31st of May transcript, page 85.
Just a moment, Mr. Elderkin. Mr. Metaltit.
Merci, Monsieur le Président.
Mr. Altit, thank you very much, Your Honour. Sorry to interrupt you. I'm not sure that the detail of the interview can be public. The details of the interview between the Rwandan expert and Mr. Kabuga. The prosecution gives us many elements and details about their discussion about the charges, but I'm not sure that this extract can be public.
Why is that?
Mr. Altit. Well, everyone here within the defense team has their own opinion, but each and every one of us think that it shouldn't be public because of the presumption of innocence, because Félicien Kabuga speaks through the voice of his counsel, in particular regarding the charges, and there's no reason for him to speak on the substance of the trial through an expert about whom I said what I thought before, and echoing things that are very discutable. And I forgot, it is a medical interview, and by nature, a medical interview is confidential, unless Mr. Kabuga wants, for such or such reason, and through the voice of his counsel, that this information is public.
Mr. Elderkin?
I frankly don't see the logical difference between how the content that's been discussed in open session of matters from the Meze and Kennedy examinations would differ from what was said between Dr. Bizoza and Mr. Kabuga, nor would I consider there to be the legal privilege issue adhering to this. But that to me is, I don't fully understand.
Merci, Monsieur le Président. Oui,
Mr. Altit, well, the difference is very simple. Mr. Kabuga and myself decide of what can be public, and the prosecution has nothing to do in this, and they need to preserve the confidentiality of medical information and cannot talk about what could have been said, according to the expert, about the charges.
Thank you. Mr. Elderkin, we take the view that even interpreting what's said there as a denial of guilt rather than anything adverse to the interests of Mr. Kabuga, it nevertheless is comment on his case made in answer to a question put to him in the absence of any legal representation, and consider that it's on the record anyway, but it ought not to be public at this stage, and therefore that will be redacted. So that will happen. You may now continue.
So finally, to note for Dr. Bizoza that as he testified, he had considered dementia as a diagnosis, but that it was not consistent with his observations. And that's from the same block site that I gave slightly earlier, 31st of May, transcript 85 through 89. Finally, Your Honours, a word about Dr. Chuk. I note that her recent assessment of Mr. Kabuga took place on a day when she was told that Mr. Kabuga had not slept well the night before. And Mr. Kabuga told Dr. Chuk that he was very tired. The assessment of Mr. Kabuga was on a day when he was, for clear reasons, likely to be well below his baseline state, and so is not instructive for purposes of determining his fitness when functioning at his normal level. Your Honours, I guess this is a question that comes up because, again, a document that was only provided to the prosecution after, I believe, Dr. Chuk's report was filed, which is her CV. We didn't see that at any earlier stage, and we have put that in e-court, and I would invite Your Honours to consider that since there was no opportunity to examine Dr. Chuk.
I think, Maître Altit, there can be no objection to the bench considering the CV of Dr. Chuk.
Aucune objection.
Mr. Altit, no objection, Your Honor.
Her expertise is as a general medical practitioner with no special qualifications, training, or expertise in mental health disciplines such as psychiatry or psychology. Given that the question of Mr. Kabuga's fitness to stand trial is ultimately a question of his mental capabilities, Dr. Chuk's lack of relevant expertise must, the prosecution submits, determine that her report should not be given any weight in arriving at the fitness decision. To conclude, I reiterate the importance of not conflating speculation about how the future may unfold, even if that speculation comes from a highly qualified medical professional, with the present observable situation. A large part of Professor Meze's report and testimony concerned speculation about Mr. Kabuga's future decline, whereas Professors Kennedy and Matache Rasso and Dr. Bizoza provided assessments about his present capabilities, which is what the fitness test exclusively should consider. It is now for the Chamber to determine the weight of the evidence on either side of the balancing point. On the one side, there are the opinions of Professor Meze and Dr. Chuk, which must be severed from their extensive speculation about how Mr. Kabuga's future health may unfold. Professor Meze's evidence must be probed to test whether what the prosecution submits are indeed weak foundations, while Dr. Chuk simply does not possess relevant expertise. On the other side of the balance weighs all of the other evidence that you have before you, from the medical records, from the reports of the treating physicians, from the assessments and opinions of Drs. Matache Rasso, Bizoza, Professor Kennedy, and from your own observations of Mr. Kabuga's ability to engage with these proceedings. For the prosecution, the answer is clear. The preponderance of the evidence establishes Mr. Kabuga's fitness to stand trial, and we stand ready to start that trial as soon as we are ordered. As for the separate question of Mr. Kabuga's transfer to Arusha, I'll be even more brief than Maitre Altit on that point. We are in the trial chamber's hands. Our interest is for the proceedings to happen and to happen expeditiously. Your Honours, those are my submissions.
Mr. Elderkin, thank you very much for these very helpful submissions. My thanks ought also to be extended to the interpreters for their indulgence and for the very helpful concession they've made to what has turned out to be a longer than anticipated session. Is there anything you have to ask? Is there anything you wish to ask? The trial chamber are content with the submissions that have been made. That therefore brings to an end this hearing on the expert evidence tendered in the pre-trial proceedings. A written decision will be issued, we hope, by the end of this week, certainly as quick as we can humanly muster a complete and reasoned decision. We will not issue an incomplete decision with reasons to follow. So if our hope is not realized, you can be assured that the decision will be issued very quickly after the end of this week, but I fully anticipate it to be in the course of this week. The court is now adjourned.
All rise, vous le voulez.